I would invite you then to read into the record by way of supplementing your original statement, paragraphs 62 to 65.
I have responded to this question in my previous affidavit. I have been advised to also place on record that I am a suspect in case involving the EMPD, and I therefore do not wish to answer any question regarding my interaction with the EMPD. I attach here to a copy of a statement deposed to by Ntabiseng Cordelia Kabeng, from which it is evident that I am a suspect in a case under investigation by members of the IPID, under case number 262/2023, relating to the unlawful fitting and usage of blue lights. A copy of the statement is annexed here to marked VMSA1. Other companies, I have not done any business with the aforesaid entities through any of my other companies.
Thank you. I'll then propose we jump to page 14 from paragraph 71. Under 71, you say, in respect of the individuals I list herein under, I wish to amplify my original affidavit, and then you detail the individuals. Could you read the headings and the relevant sub-paragraphs to the name into the record, starting with sub-paragraph 71.1?
I have answered this question when I gave evidence.
Read the name as well.
Oh, sorry.
Yes,
okay.
yes.
Minister Senzo Mkhunu, I have answered this question when I gave evidence. Former Minister Bekitele, I have partly answered this question when I gave evidence. I do, however, wish to state that I am a suspect in a matter under investigation which relates to my interaction with him, as was made clear to me during my questioning by IDEC, and as was later recorded in the statement I made in terms of the provisions of Section 204 of the CPA. Former General Komotso Phahlane, I have answered this question when I gave evidence. Lieutenant General Mkhwanazi, I have partly answered this question when I gave evidence. I do, however, wish to state that I am an accused in a matter on trial pending before the Johannesburg High Court under case number SS98/2025. I have also noted that Lieutenant General Mkhwanazi has stated under oath that he recorded the conversation we had on the day I met him. I now invite him to disclose this recording to Commission so everyone can hear firsthand what happened on that day. I respectfully point out that I do not understand why such an important piece of evidence have not yet been subpoenaed or voluntarily handed over to the Commission. Lieutenant General Mole Fefani, I have dealt with this issue in my previous affidavit. Major General Feroz Khan, I have answered this question when I gave evidence.
Thank you. I would then, on my reading, it would appear that we should take it from paragraph 72, because you are responding directly to the paragraphs in the subpoena. You start with paragraph 2.3.2, and just to quickly remind you, that had required you to speak of your involvement in the incident of delivery of impalas to General Sibiya and any other forms of gratification given to General Sibiya. You deal with that at paragraph 72? 72 and up to 74. Thank you.
I'm a suspect in a matter under investigation which relates to my interaction with him, as was made clear to me during my questioning by IDEC, and as was later recorded in the statement I made in terms of the provisions of Section 204 of the CPA. One of the matters related inter alia directly to the issue of the imbalance. Another of the matters relates to payments of gratification.
And then that would take us then to your response to paragraph 2.3.3, and this concerned the circumstances in which Sergeant Ngosi came in possession of your Luxor Africa Bank card. You deal with that at paragraph 75.
Luxo is a co-accused of mine in the Medicare matter, and therefore I cannot comment and or provide any evidence relating to that matter. I therefore exercise my constitutional right not to answer any questions regarding the said matter, as same will violate my constitutional fair trial rights under Section 35, including my right to silence.
And proceeding then to your paragraph 76 to 78 in response to paragraph 2.3.4 of the Regulation 10.6 notice, which required you to speak of your involvement in the loan or funding agreement entered into with Mr. Sulem Karim on or about June 2024.
I have given instructions to my legal team to endeavor to obtain relevant paperwork on the matter relating Mr. Karim. At the time of signing this affidavit, they had not yet obtained anything, and I thus observe my right to supplement this affidavit regarding this aspect. Notwithstanding a thorough search of the records in my possession, I was unable to obtain any documents relevant to the question under reply.
Thank you for that. That will then bring us to a response to paragraph 2.3.5 of the Regulation 10.6 notice, which had asked you to comment on your appearance at the ad hoc committee and whether you were ever induced, threatened, or influenced to give false evidence, including the details of who induced or threatened you to give false testimony, when, how, and for what purpose. You deal with that from paragraph 79 to 83 at page 17, if you could read those into the record.
May I just quickly raise something, Mr. Matlala? It relates to paragraph 77, saying that you thus observe your right to supplement this affidavit regarding the... I'm not altogether sure that it's a matter of right for you to supplement. Perhaps this is a legal question which maybe Ms. Missy should respond to. And I've seen this point being made a good few times in this affidavit. It was already an indulgence for you to supplement, and something that I granted or allowed without any reservations. I just want to avoid a situation where it's suggested that it's something that should happen as of right. Ms. Missy?
Chairperson, this directly relates to him claiming the rights of privilege in terms of Section 3.4. We would be required to show or give factual basis why it is that he wants to claim it. But in order for him to do so, he needed us to find that piece of information that he wanted us to research and provide to him so that we can confirm, in order to allow him, or rather enable him, to claim his right before this commission when it relates to issues that have to do with Mr. Karim.
I read this differently, Ms. Missy. I read this to be saying Mr. Matlala is asserting a right to supplement the content of his affidavit with regard to the issue being raised about Mr. Karim. I did not understand that to relate to the privilege that Mr. Matlala is claiming, or am I misreading this?
Chairperson, you are correct insofar as that he's asserting a right to supplement the affidavit in order for him to be able to claim the right of privilege, because as it stands, he has informed us with regards to why he would want to claim the right to privilege. But in order for us to do so, we'd have to lay facts to it, as previously argued rather on last week Monday. But we were not able yet to obtain the information that he needs. And so it put us in a position where we had to answer how would we then later deal with it if and when we do obtain that information that would put the commission into light that indeed he's either suspect or an accused, and therefore he would be in a position to claim the right to privilege.
Can you please take me through paragraphs 76 to 78 and show me where it's intimated that with regard to Mr. Karim, Mr. Matlala wants to raise the issue of privilege.
Chairperson,
Again, I repeat, I'm probably misreading or
no,
misunderstanding.
Chairperson, I agree with you that it doesn't categorically say so. I'm simply explaining why it is that he was asserting that right with regards to claiming.
I guess my point is, where do you get that? Where do you get what you are saying? Because I do not see it in paragraphs 76 to 78.
Chairperson, in that instance, the only submission that I can make is that should we have come across or should we obtain that piece of information, then the supplementary affidavit, he would then refer to it to say the reason why I had asserted such a right was because of this facts that are now being averred in this affidavit and or statement, Chairperson.
Let's leave it there. I do not understand you. Let's leave it there. Mr. Matlala, do you want Ms. Sildo to repeat a question, or are you in a position to go ahead and respond?
No, it's okay, I can go ahead.
Thank you.
Chair, before we do, I
Yes.
think perhaps in fairness to Mr. Matlala, we should consider the contents of his paragraph 17 in the original statement regarding this loan and the loan agreement. And in that paragraph, he states, I'm of the view that I may incriminate myself by answering questions related to this loan agreement, as I believe it forms part of the Medicare criminal matter which is pending before court. It's just that my reading of paragraph 76 and 78 don't tie back to the answer given in there, and instead they speak mainly of the right to supplement.
Yes, yes.
Which doesn't answer the chair's question. But
Which
I
is what
thought to bring
caused me to raise the question.
To bring to your attention.
But thank you for
Thank you.
for that, Mr. Yes, Mr. Matlala.
So then you have read your paragraph 76 to 78 of your affidavit into the record to supplement your original response to paragraph 2.3.4. That then would take us to 2.3.5. And at the time, 2.3.5 called on you to speak to your appearance at the ad hoc committee and inquired whether or not you had ever been induced, threatened, or influenced to give false evidence. And if so, that you provide the details of who induced or threatened you to give false testimony, when, how, and for what purpose. You respond to that specific question in the affidavit at page 16, starting from paragraph 79 to 83.
I am not responding to this question for the following reasons. When I attended the ad hoc committee, I was not yet arrested and charged as an accused on the Medicare matter. I was also unaware of the fact that I was a suspect on some of the issues I was questioned on. It has now emerged that I am a suspect in a matter I was then questioned on, and the same are under investigation, as was made clear to me during my questioning by IDEC and as was later recorded in the statement I made in terms of the provisions of the Section 204 of the CPA. I therefore state categorically that I'm not prepared to answer any question I have previously answered on which I have now been charged or in which I am a suspect. Answering such questions now will violate my rights to a fair trial and my right to silence and my right not to incriminate myself. I have also been made aware of the fact that stand to be accused of having made previous inconsistent statements, and more importantly, that I can be charged with perjury if I deal with any of the ad hoc issues.
If I can just, by way of seeking clarity, you do note that if one has regard to the question posed to you at paragraph 2.3.5, you haven't answered the key question there, whether or not you were induced, threatened, or influenced by anyone. Should I understand you correctly that your position is you cannot answer definitively to that question because any response you give thereto, you run the risk of incriminating yourself?
Yes, Commissioner, you're right.
including an answer that says, no, I was not induced.
My worry is if I say no or yes, then the next question, let's hypothetically saying I'm saying yes. The next question will be by who and then why. And part of those who and why might somehow end up incriminating myself.
Okay. We will come back to the issue in the fullness of time. Just wanted to get some clarity. If you recall, then moving on at paragraph 2.3.6, you were asked to comment on the recording of your interrogation on December 2024 and May 2025 by witness C or any other police officers who interrogated you after the arrest. You deal with that at page 17 at paragraphs 84 to 86.
I have been provided with copies of any of the recordings of my interrogations, whether the same way in December 2024, May 2025, or thereafter. I have dealt with this issue above. Legal argument will be made on this issue as to why I should not answer any questions relating to these recordings.
When you say this issue has been dealt with above, you mean in the body of this affidavit, where it is suggested, as the affidavit does, from paragraph 41, that you intend to launch a challenge to the seizure of your cell phones, as well as your challenge to... Now, I just see the cell phones. Where you say above, where do you deal with the issue of the recordings? Oh, you do please refer to page 9, paragraph 35. You stated paragraph 35, I have learned as a result of information obtained from the Commission that the subs have obtained a number of statements from me in violation of my constitutional rights contained in section 35. And then you reference certain recordings. Is that what you mean?
Yes.
So, if then I reread your paragraphs 84 to 85.
Maybe, Mr. Law.
Yes.
The paragraph 35 is about statements, but if you go back, paragraph 32 and 33, that's where it speaks of recordings. So he distinguishes, Mr. Matlala distinguishes recordings and statements.
Yes, at 32 he says, I only learned later that the interrogation of me and my responses were electronically recorded in paragraphs 32 to 38. You will not answer until the question of the suggested violation of your constitutional rights is determined by the commissioners.
Yes, but not only that, Commissioner. Also because those recordings, it has been made clear in court that they are currently under investigation. So we do not know which part of the recordings are under investigation. So I cannot recklessly just answer a specific question, not knowing whether is it the one that is under investigation or not.
Perhaps if you could say slightly more, under investigation by who?
This was said in court, so I will assume that it is the same investigating officers that are investigating my current case that I'm attending in the Johannesburg High Court.
So they are also investigating these recordings?
Yes.
Could we request, perhaps to your legal representatives, to obtain that portion of the transcript?
Of course, yes.
In court, because I'm not sure I understand what you mean by the claim that the recordings are under investigation. So perhaps if we get the transcripts, I might gain a better understanding.
It's okay, we'll get the transcripts, but also during the disclosure, it was during the pre-trial actually. So when it was during the disclosure of the docket, and then we've noticed that there were no recordings there, and then my counsel requested for those recordings, and then the state advocate said no, they cannot issue us those recordings because they are a separate matter. They are under investigation. But as you said, we will get the transcripts and then it will explain everything.
And I think just so we don't talk past one another, we would appreciate those transcripts by tomorrow, so that when we resume tomorrow, we know what the actual position is and how we engage with you on this matter.
That will be very hard for me to promise that I can be in possession of those things by tomorrow. Because, as you know, I don't have access to any... When I leave here, I'm going straight to CMAX, so I won't be able to make any telephone calls, but I will ask that after they adjourn here, then I at least consult with my legal counsel, and then I will ask them to get that on my behalf.
Hence, I specified that I think the request is more to your legal team through you, because I appreciate your position, but I would like to believe that your legal representatives are in a position to obtain the relevant transcripts that assist you in this regard and assist the Commission to understand how to deal with the matter of the recordings.
It is not be something that will be required the first thing in the morning, because obviously if you look at time now, they are going to request them tomorrow morning, maybe around 11, 12, then we'll be in possession of those transcripts.
Let me quickly raise a matter of clarity, Ms. Sillo. If I did not misunderstand you, I thought you said something about the Commission making a decision on the question of the lawfulness or otherwise of the manner in which the contested evidence was obtained. I'm sorry. Or did I misunderstand you?
No, it's not. I don't say that. I say
Okay.
in his affidavit,
Yes,
he
okay.
suggests that is an
Okay.
issue he's going to raise before yourselves.
Okay. Let me tell you my understanding. You'll correct me if I'm wrong. My understanding was that the decision that he says he's seeking is a decision that will be made by the court on the lawfulness or otherwise of the manner in which the evidence was obtained. And with us, he's then saying, until that has happened, the Commission should be barred altogether to traverse that terrain. So a decision on the lawfulness or otherwise is not one that should be made by the Commission.
Indeed, Chair, I agree
All
with
right.
you. I was
Okay,
reading from
okay.
his affidavit, which is what I had understood.
Yes.
Him to suggest in the affidavit, but I'll hasten to add that this is part of the legal argument and the points raised in limine that I understand perhaps are still to be argued before yourselves. So I would park that issue.
Okay.
But he had the affidavit seems to suggest that it's a legal argument to be made to yourselves. And there,
All right, okay.
Chair, you will see at paragraph 40, it says full legal argument will be made to the Commission on this issue.
Maybe we should not open that door. We should
Yes.
wait to hear if anybody will still raise that issue, because we are hearing the evidence now.
Indeed,
So
Chair.
maybe who knows? Maybe nobody will go back to that now that we are hearing the evidence. And Ms. Missy said what will be raised will be the question of the privilege.
And what I sought to establish here
Yes.
is the basis, because it's not articulated in the papers.
Yes.
And that's when Mr. Matlala raises the question of the recordings being under investigation. So that's what I was trying to tease
Okay,
out,
all right.
to understand who's investigating and where he learned that from.
All right. Yes, Ms. Missy?
If I may, Chairperson, we wanted to address the issue with regards to the practicality of getting those transcripts. Because what would happen is that the attorneys would have to put in a request from the transcribers, as I'm instructed, to obtain that recording from the courts. I forgot what the title is to the individual who does the recordings, and then obtain it, at which point would then get access to it. So to say that we'd have it by 12 o'clock tomorrow, Perhaps it would be overambitious of us to assume that it's even practically possible. And if we make that undertaking, then it comes back and it may seem as if we're trying to frustrate the process, but practically it doesn't seem possible that we'd have it tomorrow. They are obtainable, it's just a matter of the timeline.
The timing, yeah. Unless things have improved significantly from the time I was last in practice, I think I agree with Ms. Missy on the practicalities.
I'm willing to accept that. I'm going to challenge her on that, except then there is a gap in the logic that is set out in the affidavit. So perhaps in the course of argument, we might be assisted with more facts to support what is set out in his paragraphs 84 to 86.
Thank you, Ms. Solo.
Thank you, Chair.
Chairperson, if I might make a suggestion that would try and aid and or assist the Commission in moving forward whilst we wait for that recording, because there's an attorney of record who was present at those proceedings, would it be of any use for him to address that particular point, because he's heard what was said in the ruling or rather judgment made with regards to that? If it would be of any use, we perhaps could assist in this.
I don't think so, because this is a matter of evidence, and Ms. Silo is engaging Mr. Matlala at the level of testimony by Mr. Matlala.
The only issue I seek to establish, and I think it was triggered by Mr. Matlala's response, that the recordings are a subject of an investigation. So that's the only clarity I seek. Who is investigating? What does that mean, that they are subject of investigating, and who is investigating? And that is because when I engage Mr. Matlala on these issues, I will seek to persuade the Commission that to the extent that they may be under investigation, that does not preclude Mr. Matlala from speaking on these matters, because it's the recordings, according to him, that are under investigation. It's not him per se who's under investigation. So I'll leave it there for the moment, Chair. When we come back, we perhaps will get better insight.
Mr. Maybe before you then move on, now that we seem to be agreed that we won't have the transcript anytime soon, then maybe let me ask my clarification question. Mr. Matlala, the investigation that you speak of into these recordings, is it by the state or by your legal representatives?
The investigation.
Yeah, you said that there's an investigation about these tapes or these recordals of you. Is it an investigation by the state or by your legal team?
By the state.
Is it by the state?
Yes.
And what in particular is being investigated about them? What was said is going to be investigated?
That is something that I don't know, but what I know is they just said that whatever has been I've mentioned in those recordings, for those things I'm being investigated. So I cannot tell what is it exactly what they're investigating there.
Okay, all right. Thank you. And then lastly, at that paragraph 84, Ms. Silo, it's either a word is missing or a word that is there shouldn't be there. 84 reads, I have been provided with copies of any recordings of my interrogation, whether same in December, May.
I think of any other words that shouldn't.
Have you been provided with recordings?
Yes.
You have. Okay, so we must take out, I have been provided with copies of the recordings. That's how it should read. Thank you.
Thank you, Commissioner. That then will take us to your paragraphs 87 and 88. You are responding to paragraph 2.4 of the Regulation 10.6 notice, which required you to speak to the nature and extent of your relationship with the EMPD, including individuals employed therein, including agreements, actual